y'all for taking time out of your day, your evening, to be here with us tonight. And I know I've seen a lot of things on Facebook, there are various Facebook groups, people either bashing contract for deeds and land contracts, or they love them or hate them. So when I was putting this together, I was thinking of had this concept of Al and Peg Bundy versus Claire and Heathcliff Huxtable. Because it can either be a wonderful, beautiful marriage, or it's just straight chaotic until you hit the grave. So, so yeah, let's talk about these items. So, feel free to connect with me on LinkedIn, Facebook, Instagram, Meetup, YouTube, Google+. Also, I'm on Twitter, but Twitter I have too many characters. It's like you have to drop off the A. It's Mortgagematic US. There's a limit. See, social media, connect with me. Love to engage with you as well. Let's see. So what we're talking about, about Mortgagematic USA. So, you know, kind of in this debt space, you're like, why are you throwing good money after bad, right? Well, it's to be a lien lord, to help out communities, help homes, to help families, to help folks stay in their houses. And if they don't realize the value of what they're doing and staying in that property, then maybe we can find someone that does value that property, and it will help the neighborhood grow. And so it's also an exit strategy for life. I'm just a couple of days out of getting my DD Form 214 so I can retire from the Air Force. So this is my exit strategy from the Air Force. This is my why. And I got here because of Scott Carson, just flat out here. Right? So when you learn about non-performing notes, you either got two of the big ball players, or Eddie Speed, who actually introduced me to the concept. But Scott Carson got me this far, and so I will forever be grateful for him for that. But I'm not a guru. I'm not perfect. I make mistakes like all the time, like everybody else. So our objective is to just go to the top 10 questions about contract for deeds, and I couldn't think of anyone better to reach out to about that than the law offices Sottile and Barile. And Franco's been fantastic in finding the flaws and the errors before you hit that buy button. And that's exactly what you need. And so there'll be Q&As to follow. So contract for deeds, right? It's a marriage. Whether you realize it or not, it's actually, it's a marriage, it's a contractual marriage between you and that homeowner, because you both have some type of obligation to each other for the duration of that contract. And so it could either be, you could either be Heathcliff and Claire, or you could be Alan Peg Bundy. And that was kind of how I look at land contracts. So without further ado, I will pass this on over to Franco. Let me give you the share. Let me share. Oh, let's see. Sorry. Share screen, and I'm going to share it with, I need to give you control. How did I do that last time? You stop video, rename, highlight, I'll record. Let's see. Sorry guys. New share. Desktop. We are recording. Right. Okay, how did I give you the screen last time? Do you remember?
I thought you had shared the screen. You want me to give that a try?
Yeah, can you ask to share the screen, to take over?
You cannot start screen share while the other participant is sharing.
Ah, okay, stop share. Boom, I stopped sharing. Now you got it. Boom.
You see my screen?
I do. I see your nice mug and your beautiful office.
Oh, fantastic. All right, Brady, I want to thank you for having me. I know Brady now just for about a few months, and it's been a great ride so far. He's given me some files to review, and I think this is a great topic to bring about to participants. What I want to share with you is a PowerPoint presentation, and let me get this thing going here. So the law firm is Sottile and Barile LLC. Again, the topic tonight is top 10 land contract CFD questions. Just to give you a little background of the firm.
I can't see your slides.
You can't see the slides?
No, you might want to do hit it where you share your screen, like because you got control, but you got actually share your screen, and then your slides will pop up.
Can you see me now?
I see your slides. Now I just need to go full screen.
Okay, let's go full screen. Okay. So like I was saying, the law firm is Sottile and Barile LLC. Tony Sottile is the other half of the firm, and we started the firm back in April 2015. So while we're only about 2.5 years old, both Tony and I have a lot of experience in the creditors' rights arena. So Tony's got a great wealth of knowledge in the bankruptcy world. I started off as a title insurance defense attorney, so I knew quite a bit about the title insurance background to understand title. Title's a difficult thing to understand, especially as an investor. You look at a property, you want to purchase that asset and start to take the property over however you need to be. However, there are some title issues that come about when you do in fact get that asset. So like I said, we started in April 2015, and we've got a wealth of knowledge, and we've got a lot of attorneys on board now that help us out, help us go out and bring on more work. And in the meantime, we do give quite a bit of good service to our investor clients, especially when it comes to the pre-purchase. So right before you're about to buy that asset, whatever it may be, we can do the review on the collateral file that you get through due diligence, as well as the title report. So the first slide we have here just deals with what to look for in that collateral file and title document. So the first thing you're going to see is that collateral file. It's going to come with a lot of documents. So your best bet is, if you want it reviewed or reviewed properly, or at least remove some of that risk when you're buying that asset, is to have my office take a look at it. And we provide that service for all of our investors. It's a fee of $100, but we feel that it's a fee well paid, especially since you see some of the files we've seen can get a little hairy. So the first thing you're going to want to look at this collateral file, you're going to ask, where's the land contract? I've seen some collateral files that don't have the land contract, which is pretty surprising. So I would assume you're not buying the property from a homeowner. You're buying it from another investor, from a seller. They're most likely selling you not just the property, but the land contract itself. If there is no land contract, go back to the seller, ask for it. If they can't produce the land contract, and it's quite certain that there is a land contract vendee in the property, it's going to be difficult to do a forfeiture. It's not impossible, but it does become a little more difficult to get everything in line. You're also going to want to order a title report. You can get those pretty inexpensive through some of the title agencies that work with all your investors. Again, this is something, if you'd like, you forward that along to my office. We do the review for you, and we look at any issues with possible liens against the property that appear. You'll see some utility liens, you'll see water liens. It's possible you'll see some liens against the borrower. So again, we can provide that review and kind of take away some of that risk when you do buy it, to at least tell you, hey, look, this looks pretty clear. Go ahead, and we recommend that this is a good property we could eventually forfeit if that's what you needed. Also, with the collateral file, you're going to want to see a payment history from the original servicer or the original seller, showing all payments from the origination, so that we can at least see some sort of history. Because if it becomes time where a borrower will dispute a case in court, you're going to need to produce that payment history. So it's pretty important to have that. And another item are the notes that were taken from the seller with the borrower, any phone calls, any letters, any correspondence at all. Have those documents ready, so at least you can rifle through the file and see what's going on with this property, what's going on with this borrower. But again, that's more towards your business sense, whether this is a good deal or not. What I do is I make sure I see those documents. So again, the land contract is big. Make sure you have that. Your title report is going to show all the liens that are on the property, whether they're on the borrower or on the seller. So if we go to slide 2. That main question is, do liens attach to a land contract vendee's interest in the property? So in the land contract world, the vendor is the seller and the vendee is the purchaser. If you want to look at it as lender-borrower, the vendor is the lender and the vendee is the borrower. So here we're just stating liens of the borrower. They don't normally attach to the property. However, there are some exceptions. The main ones are federal liens. So federal tax liens, federal judgment liens, child support liens do attach to the property of the vendee, of the borrower. So if Jim Smith is the borrower and there's any of these type of liens on that property against Jim Smith, that's going to attach to the property. So you can still get those liens released, but there's just a little more work that needs to be done. Any other lien that's against that borrower will not attach to the property. We had a case in point where we did a title review. We ended up doing a release of the land contract from the borrower, had it signed by the borrower, had it signed by the lender, and the lender went ahead and tried to sell the property. Title insurance company came out and said, hey, what about this judgment lien that wasn't released? And there was a lot of fighting with the title insurance company, but we finally came around to say, those liens don't attach. It was just a judgment lien. It was from a credit card company, and it took a lot of working around it. But the title insurance company finally came down and said, no, you're right. Those liens don't attach. So we do have that wealth of knowledge where we can then tell you which liens attach, which liens don't. The main liens that will always attach are those liens against the seller. So if there's we see a lot of utility liens, or city violation liens that are against the seller, those will attach to the property. So if you are buying a specific asset and property from that specific seller and there's a lien against that seller, you're going to have to clear title. You're going to have to clear that lien. There's no way around it. It will stay on that property. It will stay with you. If you're looking to sell the property later, you're going to have to take care of that lien. So that's part of our collateral and title review that we provide for our investors. It has that exact language in it. If there are these type of liens, we make sure to put a note, hey, there's a lien against the seller. These need to be taken care of. So just something to watch out for lien purposes on the property is A, who's it against, and B, if it's against the seller, you got to find out what that seller's going to do. Are they going to pay those off, or you're going to have to walk away from that purchase? Also, with the title report, you're going to see if there's any delinquent taxes. That's one thing you do have to worry about in case some reason those taxes go into forfeiture. And again, we're talking about Ohio, Michigan, Kentucky, and Indiana. So these are the 4 states we practice in, the firm practices in. And in those 4 states, there's a process of having those taxes forfeited and eventually sold at a tax sale. So that's one thing we'll be able to see from a title report, if the taxes are delinquent or if there's any type of tax sale that's pending. And we will then alert the investor right away. And then the title report also is going to show you whether that land contract is recorded or not. And the basic premise is, you hear a lot, do those land contracts have to be recorded? We'll touch base with that in another slide, but it's not fatal. If it's not recorded, it's okay. As long as it's in the collateral review, you just want to make sure you have at least a copy of that land contract. So we get questions a lot of whether these land contracts are the same as a note and mortgage. They're not. And again, the main distinction is ownership of the property. So with a land contract, the seller, you all as investors, you still own that property. So equitable title goes to the borrower. That's why those liens, those judgment liens against the borrower do not attach to that property. And that's why the liens against the seller do. So the main point again is ownership. With a note and mortgage, the borrower owns that property. You take back a note and mortgage. The mortgage gets recorded. If there's a default of that note and mortgage, you have to go through the foreclosure process and eventually attempt to get that property back at the sheriff's sale. With the land contract, it's one document. All right, it's the only document you need. A lot of land contracts we do review. We notice that there are promissory notes in there as well. There really shouldn't be. Again, that's not fatal if there is a promissory note. It's just not necessary. What you don't want is you don't want a borrower, coming out and saying, "Hey, I signed a promissory note and a land contract, so this is a mortgage." Well, it doesn't change ownership. The land contract, you as the seller, you still own that property. So just be careful, with land contracts. Since you do own the property, you have to watch out for water issues. If there are water bills, those are normally going to be paid back by the seller. So if there's an agreement that the borrower is going to pay those water bills, that's fine. Just stay up on it. Make sure those water bills are paid. Eventually, they'll go back on the seller. All right. Does the land contract have to be recorded? Each of the states, Ohio, Michigan, Indiana, and Kentucky, they all have statutes that say, yes, they have to be recorded. While they have to be recorded, you would think that it's a requirement that if they're not recorded, it's fatal to any type of forfeiture or foreclosure. That's not accurate. If the land contract is not recorded, we've still been able to do forfeitures. The main crux of a land contract is it a land contract or is it a note and mortgage? Or is it a lease to own? Is it something different? So if all of the requirements of the statute are in the land contract, you're fine. Even if there's some provisions that are not in there, we've been able to find ways to get around that. So again, the recording of that land contract mainly helps the borrower. The borrower likes to claim a homestead exemption when they use that property as their principal residence to get a tax reduction. So that the main times I see that happen or that being pushed is that the borrower wants that recorded. Well, since the statute says you kind of have to, and the borrower is requesting it, you might as well go ahead and record that land contract. I don't think it's fully necessary. I think it makes it easier if there's a default and you need a release. All you need is a signed release from the borrower. You don't need to record that either. So just make sure you hang on to all the documents, hang on to the originals, just in case later there's some issues with the borrower. And that final point, if that land contract is recorded, any assignments of that land contract have to be recorded as well. While it is necessary to have assignments of land contract to the new investor, any land contract that's recorded, those assignments must be recorded as well. So just keep that in mind if those land contracts are recorded. Okay, foreclosure versus forfeiture. That basic premise, when a purchaser defaults on a land contract, the seller has two legal options. One's forfeiture and one's foreclosure. Both have a judicial process, as you can see with the foreclosure, and I'm sure you've all heard about that process of foreclosure. It's time consuming, it's expensive. You need title reports. You need to make sure all the parties are named correctly. I still recommend getting a title report for the forfeiture. However, don't forget those liens, those judgment liens especially against that borrower are not going to attach to the property. Now with a foreclosure, you're going to have to name everybody. The process is longer, and just to give you a frame of reference, a foreclosure is going to take you, in all the 4 states that we deal with, between 6 and 12 months. 6 months is really pushing it. That's, we've become pretty efficient in our office, but I would say 6 months is pushing it. We do adhere to all of the legal requirements. We don't cut any corners. We just make sure we do everything legally. We do it efficiently. We have a great staff. But again, borrower disputes, you're looking at mediation. You're looking at possible answers, or maybe a counterclaim or a cross-claim. And that obviously extends that time. And again, they're expensive. you're looking between, you know, $4,000 and $6,000 from the beginning to the end. So once you get to that foreclosure sale, that's the cost. So they're pretty expensive. The forfeiture process, again, if it is judicial, I consider it efficient and inexpensive. They're pretty quick. They act more like an eviction than anything else. Between the 4 states, there's some sort of notification that you give to the borrower. After that, you can file that forfeiture action, and once it's filed, it's pretty streamlined to get you to that judgment process. So those are the main differences between foreclosure and forfeiture. A lot of it has to do with the amount of time it takes and the expense. So are there differences between Ohio, Indiana, Michigan, and Kentucky in filing a forfeiture? Yes. Ohio, I would say, has the most stringent of those differences. So in Ohio, if a land contract is over 5 years old, or the purchaser's paid over 20% of the purchase price, the seller's forced to file a foreclosure. So there's really no option there. The option would be if you went ahead and said, well, this contract is less than 5 years old, but I still want to do a foreclosure. I wouldn't recommend that. You know, I would assume the goal is to get that property back into your hands as soon as possible and get it turned over to either a rental or selling it again. So if timing and expense is an issue for you, you're going to want to, you know, choose that forfeiture route. And again, that idea in Ohio, it's only to Ohio that 5-year-old or 20% of the purchase price, you're forced into a foreclosure. We've had a bunch of those. We've had some that are really a couple days after the 5 years, and that's all it takes. We've had some that are a couple dollars, you know, above the 20%. It's enough to push you into foreclosure. If not, if none of those exemptions apply to you, we'll go through the forfeiture process. Indiana, that process is called a foreclosure. However, you still get the same benefits under the forfeiture process. So you're still looking at an expedited system, and again, an inexpensive system. So, and in Michigan, the only difference in Michigan than any other, it's treated almost like an eviction as well. You take it to a judgment for possession, and after that, the borrower has a right to redeem for 90 days. So once you go through the process of filing that forfeiture, eventually getting your judgment for possession, once you get your judgment, you can't just go and take over the property. The borrower has 90 days to redeem, and that redemption amount is based on the reinstatement value. So the issue with Michigan is if you file the complaint, and in between the complaint filing and your hearing for your judgment, the borrower says, okay, I'm going to come back, I'm going to reinstate this loan. They can come back and reinstate it. You have to dismiss the case. And then if you have to start over again, you have to start over again. In Ohio and Indiana, you don't have to worry about that issue. It's an acceleration. So you worry about making a payoff once you file that complaint. You don't have to worry about the reinstatement. So if you've got a borrower that's constantly doing this to you, or you know, paying that reinstatement and then defaulting after 2 months, I guess my recommendation in Michigan is maybe wait till they go 3-4 months past due. Might be a little harder for them to reinstate at that point. While you have to wait that long, it's still better than the foreclosure route. And in Kentucky, there is no forfeiture. You have to foreclose. It's strict. There are no exceptions, exemptions. You must foreclose. So Kentucky, there's no rules on forfeiture. If it's a land contract, note, mortgage, whatever it may be, you're going through the foreclosure process. So the exact process of a forfeiture. And again, we get a lot of these questions. You know, once I've got this asset now, I've got this land contract, I've got a borrower, he's not calling me back, I don't know what to do. Well, here's your process. All right. So as long as you're within the guidelines in Ohio, all right, not 5 years old, didn't pay over 20% of that purchase price, the borrower in Ohio must be at least 30 days past due. Well, I think that's pretty obvious. I think a lot of times they're way more than 30 days past due, but that's the requirement. Once that does happen, you can start that land contract process. By doing it, you would post a 10-day notice to vacate. Now, We can mail these from our office by certified mail, but the issue is the 10 days doesn't run until at least it shows that it's been received. There's some case law that shows that that notice has to be at least received. So you're putting yourself behind the 8 ball by losing some days. So it is in your best interest to find some boots on the ground, to find maybe a property manager, somebody to help you out, to at a minimum to post that notice for you. Because what you can do, that 10-day notice, you print it out, we prepare those notices, we send them to you, you post them on the front door. You're done. That's service. 10 days later, 10 calendar days later, we're able to then file a complaint for forfeiture. And once you file that complaint, there's a hearing that's set, and it's usually between 3 and 4 weeks after the complaint's filed. The borrower is served by either a sheriff or a bailiff for personal service. And at that hearing, we appear there with a judgment for possession. Excuse me. We normally get those granted, and once they are, you can then prepare the case for a set out, for a move out, which is done by the bailiff. So the key is, as long as they're 30 days late, the borrower, as soon as you post that 10-day notice, we're able to file the complaint. So from that process, you're looking at around 45 to 60 days before you get judgment. That's a pretty quick process. If you're asking me, talking about a legal process to take 45 to 60 days, that's not bad. That's pretty expedited. So that's the Ohio process. You post your 10-day, we file our complaint after 10 days, we go to the hearing for the judgment, we get our judgment, and then we then contact the bailiff and do the set out. Those set outs are usually done within a week or two. So that's a pretty quick process. Indiana, pretty similar. Once that borrower is in default, we send out a demand for payment. Once that's done, that 30 days expires, we file the forfeiture. What's different about Indiana is, as long as the borrower doesn't dispute it, doesn't file an answer in court, we file the motion for default judgment 21 days after the borrower is served. So within a week from the complaint filing, we normally get these borrowers served. We assume the borrower's in the property. So if they're in the property, they're going to be getting mail, they're going to be getting served. So they'll get served pretty quickly. 21 days after they get served, we file our motion for default. Again, as long as there's no dispute by the borrower, we can normally get that judgment within a week or two. And then after that, we file our writ of possession, and you're in the same boat as you were in Ohio. You're contacting the sheriff, or at least we're contacting the sheriff to get a set out date. So again, you're looking at 45, 60 days, maybe 70 days from front to end. And again, it's all based on if this borrower doesn't dispute. So if we're going just streamlined and we're able to get good service, again, you're looking at 60, 70 days tops. In Michigan, we have a 15-day notice of forfeiture. Now, this gets mailed by my office. So as soon as an investor refers a file to us, say, hey, we've got a default here, here's the documents, we send out that 15-day notice of forfeiture. That notice of forfeiture has a reinstatement amount that you can get from your servicer. And once we get that, we put that in our notice. After that 15 days expires, we file the complaint. And similar to Ohio, you're looking at a hearing date between 3 and 4 weeks from the complaint filing. Again, the borrower needs to be served personally. Once that borrower is served, we have a hearing. If everything goes smoothly, we get our judgment. And again, the big issue in Michigan is twofold. One, the borrower can redeem at any point that reinstatement value. And two, the borrower has that 90-day right of redemption. So the right of redemption in Michigan basically states that borrower gets to stay in the property for 90 days from the judgment date. Nothing you can do about it. You just have to wait your turn. Once that 90 days hits, we'll contact the investor and say, hey, it's day 91. Take a look at the property, see if the borrower's still there. If the borrower's not there, you can take the property over. If the borrower is there, we have to file an application for an eviction. It's not like we're restarting the case again. It's just an application. The judge normally signs that within a couple of days, and the bailiff goes out within the next couple of days. So after that 90-day right of redemption is passed, you're getting that property back pretty quickly. And again, Kentucky, not applicable. you have to go through the foreclosure process.
Fascinating.
So just to follow up, what happens after I obtain that judgment for possession in a forfeiture action. So if you're looking at Ohio and Indiana, you've got that judgment. Once you have that judgment, you can ask the court for a writ. That's something that we do in our office, and we just confirm with you all to make sure the borrower's still there. We file the writ. Within a week or two, you're getting a phone call from the court officer starting to set up the move out. So just be prepared to have movers there, to have a locksmith there. Make sure you have some people there so that you can assist the court officer in taking the property over. So the court officer physically removes the borrowers, and then the investor and their people will take care of the property. Michigan, again, you just got to wait for your 90-day redemption after judgment to do the kind of the same thing. That application for an eviction is your writ. So your Ohio and Indiana writ is your Michigan application for eviction. Again, once that's filed, we'll take care of the filing of it. It gets filed within a couple days. The judge signs it. Then a couple days from that signature, we're having a court officer go out and remove the borrower. So in those 3 states, you're having a court officer help you out. Kentucky, again, you have to file a foreclosure action. So again, once you get that property back after the court officer removes those tenants, it depends which county you're in. So again, once we get the file, we'll tell you exactly what you need to know. But some counties, some cities say you have to store the property. Some counties say you leave it on the curb. And after that, the city garbage will take care of the rest, or you dispose of it. So I can't give you the exact way of the move out. It's too up in the air. We just kind of have to wait to see once we get the file in. Well, I mean, we can tell you right away as soon as we get the file, if it's in a certain county or certain city, that what you can or cannot do towards the end. So just, if you need that information, just let us know when you do refer the file. All right, what happens when the borrower files bankruptcy? Like I stated, it's not the end of the world. There is some legwork, but it's not the end of the world. If you are in the forfeiture process, that forfeiture process has to be put on stay. Once it's on stay, the court will just keep it on their inactive docket. And then what happens, the bankruptcy estate's opened, and now you have to follow that case through the court. The one main point, and this was told by my partner, Tony Sottile, he said if the borrower files a Chapter 13 bankruptcy case, it's mandatory that you file a proof of claim. We do that in our office. Tony takes care of that, and our staff. We do that. I have to confirm with Tony, but I'm pretty sure we do that on a nationwide basis. So we have you covered in every state if that's necessary. But let me confirm with Tony. But I did talk with Tony before this presentation. He has agreed to prepare a presentation at a later date and can assist in any bankruptcy-related matter. So if there is an issue with bankruptcy, just give me a call. I'll share his information, and you guys can chat. Tony's an unbelievable guy, unbelievable attorney. He is a great business partner, great friend of mine, and you will be in great hands. His response time is remarkable. I sometimes call him a machine because he gets those emails and they're responded to very quickly. So he's very good at what he does. And again, I'm glad to have him as a partner here. So any bankruptcy related matters, shoot me an email, give me a call. We'll get you connected with Tony. And that final slide, who do I contact when I have land contract questions? There's the firm. So Sottile and Barile. I'm one of the co-owners. Obviously, Tony Sottile is the other co-owner. We've got an office here in Strongsville, Ohio, which is a suburb of Cleveland. My phone number is there, 440-572-1511. I've got my email address as well as our website. Tony runs our Loveland, Ohio office, which is a suburb of Cincinnati. So we've got Cleveland and Cincinnati and everything in between covered. So again, we do handle statewide Ohio, Michigan, Kentucky, and Indiana. We also handle more states when it comes to bankruptcy matters. And again, that's something that Tony can discuss at a later date. There's a lot to learn in bankruptcy, and he's your guy. But for today's slides and today's presentation, that's the presentation on land contracts and what to expect. I know there may be more that you have questions on. You've got my contact information. Give me a call or shoot me an email.
Excellent. Yeah, we actually, there are some questions. Would you like to go over some of those?
Yeah, sure.
Okay. The first one is the lendee, vendor. Go over that again. One more time. Paint that.
Yeah, I mean it's legal jargon, but you're going to see that in a land contract. The vendee is your borrower. The vendor is your lender. All right, so the vendor lender owns the property, if that makes any sense. You know, it doesn't make sense that a lender would own the property, but they do. And that's what happens with the seller financing land contract. Again, so the vendor is going to be your lender, and your vendee is going to be your borrower.
Excellent. And what type of title report would you recommend on these assets? An O&E, just up to the last one, or a full comprehensive? I know me, I've been ordering the full comprehensive from Pro Title, which is, you know, a little bit more expensive than necessary.
Well, you know, while it's more expensive, I would recommend a more full title search.
Mm-hmm.
I've seen some O&Es that missed a lot of information. And it doesn't matter which type of company you use. It's just when you come to an O&E, they're most likely looking at just a one owner search. Well, if that last owner was a seventh party down the line and they just sold it to the newest owner 6 months ago, well, that's all that's going to track. So it is nice to go through that full comprehensive. While it's an expense, you know, it's something I think it's worthwhile. If you're looking to roll the dice, you know, get the O&E. And again, we review whether it's an O&E or full title. We put disclaimers that, you know, since it's not a full report, we can't guarantee what happened before that owner.
Excellent. Also, too, does that having the full report versus an O&E, that can help you significantly to get title insurance, correct?
It could. I mean, once I review that report, so if it's the full search, it's everything in the last 40 years. That is your gold standard when it comes to a title report and title search. If I review it and I say this is clean, this is great. Now we review a lot of title reports, title searches for deeds in lieu, which are very stringent. You have to really make sure nothing, you know, that property's clean, and we do that type of review. So if you're getting a full search, you're going to have no problem insuring that property later in time.
Okay. Let's see, there's another question here. Okay, if I acquire a CFD that is vacant and the borrower has clearly vacated the property for 6 months or more, is there still a need to go through a forfeiture process since no eviction is needed to take possession? And,
oh, that's a tough one. I mean, that really comes down to a business decision. I mean, if you're asking an attorney like me, I'm telling you to file a forfeiture for everything. I'll give you one example of, again, if you're looking at a recorded land contract and you've got vacancy, you got to either get a signed release and record it from the borrower, or you got to file the forfeiture because it is recorded. Nothing you can do about it. Doesn't matter if it's vacant or not. If it's recorded, it equals forfeiture. If it's not recorded, that's where it comes this business decision that I've heard people take. While you can take that, I would be careful. So the one instance I can remember, it happened a few months ago, and there was an investor who was selling a property. They went ahead and obviously got title insurance because they're selling it to an individual. And lo and behold, somehow the title insurance company found an unrecorded land contract. That was enough to blow up the deal. And they wanted to know, where's the release? They don't care about vacancies. Title agencies, title underwriters don't care about vacancies. They see documents. So if it's ever found, if an unrecorded land contract is ever found, they're going to want to see a release or they're going to want to see a forfeiture judgment. So in that case in particular, the investor was able to find that borrower. I prepared the release and the release was signed. So thank goodness that happened. But a lot of times if you see vacancies, you're not going to be able to find this borrower. Again, I'd recommend a forfeiture action. Even through vacancies, we can get those judgments through publication, whether it's Ohio, Michigan, or Indiana. But again, I would still recommend forfeiture.
Okay, excellent. And then the follow-up is, can you offer a delinquent borrower cash to move out and sign over their rights to avoid forfeiture or forfeiture process, kind of like a cash for keys deed in lieu?
Yeah, we've done cash. We do a lot of cash for keys. It's a standard agreement. Just give the borrower something. Say, hey, make sure it's broom swept, it's clean in there, no damage to it. Sign this agreement, and only give them the money after you do your inspection when they leave. So upon their removal, they take all their stuff out. You go in there, you do that inspection. If it looks like they destroyed it, you send them a letter saying, hey, there's a lot of damage. We're going to deduct this amount from the cash for keys deal. But with the cash for keys deal, you want them to sign the release the same day. All right, so you get everything together all at once. And in our cash for keys deals, we put a provision in there if there is damage to the property. If there is, it's going to be reduced by the amount of money it's going to take to fix it. But if you're talking about cleaning, like cleaning countertops, cleaning walls, things like that, you can't deduct that. You just got to go in and do it. But if you see, holes, something that looks like it's going to take a little bit of money to fix, you can reduce that amount.
Yeah, more like more of a phased payment process. You meet this, we'll give you this to sign it.
Yep.
And then now we'll give you $X to do this, and then when you're done, we'll give you $X number to when it's all said and done. So kind of like a phased payment process to keep them moving forward.
Yeah, I think you're right, because we do. It's almost like a two-phase. It's some money to sign that release, and then the rest of the money you're going to get once we get in there and do the inspection. So that release is key, because if you've got that, it makes your forfeiture process, if you need it, much cleaner. But yes, you'll get that cash for keys and the release. You pay the release right away, and then you go in there for a separate payment for the inspection.
And this next question, I'm kind of in a similar boat, but I actually was able to get. I have an asset, and it has liens. This organization has several assets in a community, and they put liens on put them across multiple properties, and I was able to kind of negotiate that down based on what popped up on the title report. So the question is, what liens are collated to the property from a seller who has liens on other properties within the same county or jurisdiction?
So you're talking about a lien against the seller in that county.
And lien against the seller in the county, not specifically against the property itself, but against the seller.
Right. So those are a little odd. I'd like to see that in action, or at least see what you're looking at, because normally if you've got a lien against a seller, it's because of the damage they created on one of those properties. So I guess maybe is the question, if there's a property in a different city that they have a judgment on, will that transfer to a property they own in a different county?
That says, what liens are cross-collated to the property from a seller who has liens on other properties within the same county or jurisdiction?
It's going to attach to the whole county, to that seller entity. So I'll give you an example. You've got a seller named ABC1 LLC, and kind of the same seller named ABC2 LLC. If the lien is on ABC1, it's on all property owned by ABC1. So if, let's just say you just have one seller and it's ABC LLC, it's a lien on everything ABC owns within that county.
And they
so
all,
it's something to worry about.
And once that's cured, all properties are cured.
Well, yeah, because the lien is there's an amount on that lien. So if you satisfy that lien, that you satisfy the amount on that lien, it satisfies the lien. There'll be a release of record, and it's gone.
Okay. So does it get into a situation where we're just waiting for who's going to pay off who first?
Usually that's sometimes what happens. You know, you can always go back to the seller and say, hey, you know, you going to pay this off or what? But again, those will be shown in a good title report. Those liens will pop. And before you buy, you can go right to the seller and say, hey, you're going to buy, you're going to take care of this or not. If they don't, well, you know, that's the risk you can take.
Excellent. Let's see. Let's see. So the tax liens can be taken away. Can code liens be removed?
Yeah, again, you're looking at so you got a couple of code lien issues. You've got some for monetary, you know, and if you're looking at code liens that are mostly for safety or for issues with the property, first thing you have to do is call the city and figure out how to rectify it. So that's why you really got to be hands-on once you see those city violations. You know, city can go out there and demolish that property and you don't even know about it because there's been so many notices and so many, even a demolition notice that maybe you didn't get, but the seller got. So those are the main issues. It's not just money when it comes to city. It's mostly probably that property being, you know, in disrepair.
And as I'm doing due diligence with calling the water department, sometimes, you know, there'll be a water lien, but sometimes they'll tell me, oh, the water lien won't stay to the house it'll go with a borrower. Have you found in your areas that you serve that the water liens attach to the property, or can you get those absolved when you take the property back? And then those go to the previous homeowner.
Yeah, and this would be a good distinction between land contracts and notes and mortgage. You know, with the land contract, you, the investor, you still own that property. So those water bills, when they become liens, yeah, they're going to show up in title, no problem. But what's not going to show up in title is when you go ahead, you buy that property, and now you've got your first water bill that came in and it's $5,000. Because those municipalities, they don't always file liens quickly, or they try to send them through collections for a couple of years. So those bills can get very high. They're going to follow that owner. And as you, the investor, you own that property. So that's something that, you know, you should be able to contact the water department during the due diligence phase. I don't know if the water company will allow you to get that information, but it might be something you want to look into, or have the seller do it, you know, or put a provision in your purchase agreement from your seller. If there's any water issues, if there's a water lien, if there is a water bill, and the city's saying we need to pay it, put a provision in the purchase agreement that the seller is going to pay that. And if the seller doesn't, you can go back and sue the seller on it.
Okay.
So that's something you want to maybe put in the purchase agreement to kind of protect yourself. And that's a provision we can send to you to give to the seller to put in that agreement.
Excellent. Looks like I have one more question here. So, you know, after a sheriff's sale, you see the sheriff's sale, the chain of title. So does a sheriff's sale and the chain of title impact how far back you would go with a title search?
I mean, normally with the sheriff's sale, there's an assumption that the foreclosure was done properly. We're dealing with the case right now where a foreclosure firm failed to name a lien holder. And it wasn't even the foreclosure attorney's fault. The title report from the insurance company failed to list a specific lien. So when you do a title report for a foreclosure, you have to get what's called a judicial report. And in it, it shows all the liens, and you name all those lien holders, and then they get defaulted out. Well, there was a specific lien that was missed, and it went all the way through. The property sold in 2009, and here we are. The new investor has it in 2017. A new title report came out, a 40-year search picked up that lien. So, you know, you can say, yeah, that foreclosure deed is fine, but what it would have missed is that lien that wasn't included in that foreclosure. So again, it goes back to what kind of title report do you want? Do you want the all-inclusive title report 40-year search? I would recommend it. But if you're looking to cut a little bit of cost, you can make the assumption that if you've got a sheriff's deed, that the foreclosure was done properly. But again, it's an assumption.
So aren't quite a few of these transferred with QCDs as opposed to a special warranty deed? Have you seen that often, where you get a QCD as opposed to a special warranty deed?
Yeah. I mean, just the differences between those deeds. A quitclaim deed is that the owner of the property who's deeding it to the grantee is not saying there's a good title. It's not marketable title. They just say, hey, take the property. It's almost like an as-is deed. Those special warranty deeds that I've seen, they look more like general warranty deeds in the states that I'm in. And those, not a guarantee, but they warrant good title. That, hey, me, ABC, as the owner, I had good title to this property. So at least kind of it gives you that sense that they had good title. Doesn't say anything about, I mean, there could be some lien issues, but those are hard to fight. Whether it's a general warranty deed or a quitclaim deed, those are still hard to fight against the seller to say, hey, there was a lien, you gave me a general warranty deed. Yeah, good luck with that. There's a lot of hourly fees in that.
And so after that point, if you wanted to try to get title insurance, it's just a matter of trying to find a firm that would be willing to underwrite a policy on that?
Well, I mean, you don't want to do title insurance until you want to sell the property.
Yeah.
Or you want to sell it on land contract. Because a lot of borrowers say, hey, look, we want insurance to make sure the title is good on this. Because you can get some investors that have mortgaged a property, beyond belief above the balance of the land contract. And now you've got the borrower sitting there saying, wait a minute, I'll never have a chance to get this property back. So you'll want to get that title insurance once it's time. And at that point, you'll know whether it's good or not. But if you're doing a 40-year search prior to purchase, then you're in very good shape.
Excellent. Yeah, and just one more push for everybody to consider Franco for whenever you need a title, you need your collateral file review. I had sent him a Dropbox. We were actually at Disney, I think, when I hit the send button, and it had everything he needed. It had the title report, all my collateral files, the electronic versions of it, the pay history, and it was 2 assets, and like he had a whole thing documented within like 30 minutes. 2 assets, 30 minutes. He knows exactly what he's looking for, and it was the best money I spent. Initially, I was thinking, oh my goodness, I just paid him $200 for 30 minutes worth of work. But the follow-up questions, that's where it's worth its gold. And so I'm still trying to, because of what he found, I'm still trying to work with the seller to get them to correct or address the things that he found in the collateral file review. And so doing that can really go a long way to helping you make a terrible mistake.
Yeah, and what I'll say about that is, I can spend a half an hour on a full collateral file title review, and another attorney can spend 2 hours on it. What you're getting with me and our firm here is that knowledge. We have this wealth of knowledge. I've seen title reports since I started being an attorney. I know a lot of what I'm looking for quickly, and they're triggers for me. Quick documents that are triggers that I'm easily able to throw into these title reviews that I prepare and send back. So when I do these reviews, I prepare a 1-page review of everything, bundled together between the collateral review and the title report. Here's who owns the property. Here's the liens on the property. Here's what you need to do with some of these liens. Hey, there's no recorded land contract, but I see that there's a unrecorded land contract in the review. So, I believe it's money well spent. I believe Brady does as well as other investors.
Most definitely. All right. Well, I don't see any more questions. This pretty much sums up. Our objective was to talk about the top 10 questions he constantly gets about land contracts and CFDs. and it is a marriage. It seems like you are both encumbered with each other for the duration of that contract until all the terms are satisfied. And I thank you guys for coming out tonight, and again taking out the time that you have. Merry Christmas, Happy New Year, and I hope you'll have a wonderful 2018. Anything else?
No, thank you, Brady. I really appreciate it. Thanks for putting this on.
Yep. And hey, I when I saw that you mentioned that bankruptcy, yeah, that sounds like a great topic for another day.
It's next.
Yep. All right. Well, good night, everybody. I'm glad that this was informative and worth your time, and we'll try to do some more of this.